Thank you for tuning in to our second ever episode of Sensible Dissent, powered by Razzle Cannabis Broadcasting Network, WCBN, starring yours truly, Nicole West, and my amazing co-host, Sarah Daniel. On today's episode, I am so happy to have the owner and founder of Aura IP Law, my friend, my client, and my trademark attorney, Shelia Gibson, with us. Today, we're going to go over the current state of clarity on brands and what does and doesn't fly when it comes to licensing regulations, as well as patents and trademarks. And now, some word for our sponsors.
Ojai Energetics has the most advanced water-soluble CBD on the market. Its fast-acting, most viable products are made without synthetics. Most users feel the benefits with proper dosage in under 30 seconds, not 30 minutes like a regular CBD rich oil. Their products are created using organic ingredients and regenerative farming practices benefiting both people and the planet. Ojai Energetics provides CBD users with a dependable bridge to optimal living, promoting everyday health and well-being. To see their products, visit OhaiEnergetics.com. And to learn more about their current investment opportunity, visit their profile in the Razzle investment marketplace at Razzle.com.
Thank you guys for tuning in. And again, I have Shelia Gibson today with us, and I'm very excited to give Shelia the warm introduction that she deserves. Shelia started her career in intellectual property in a nationally recognized IP boutique firm, practicing law in a top-tier firm as an attorney over 16 years ago. She's worked with clients in every different aspect, it seems like, from biotech to medical devices, agriculture, food packaging, pharmaceuticals, and even green technology, mechanical, sports innovation, beverages. Literally, it almost seems like an endless list of things that Sheila's worked on in the way of health and wellness in regards to patents, trademarks, and IP. Shelia has counseled clients from the research to development to startups and also small businesses and even as much as Fortune 500 companies. She's advised clients in all aspects of IP, including patents, trademarks, copyrights, branding, licensing, IP transactions, IP agreements, opinion work, which I think is kind of funny that that's a thing, due diligence, and product launch. She has such a unique combination of science as well as a very strong understanding for business and the needs that a small business needs to get going. And now, being a small business owner herself, she's experiencing, I'm sure, a ton of those same pains, in addition to having received exposure in all aspects of IP, including some of the most complex prosecution, litigation, and transactional issues at prior law firms. She's learned to approach the matter with a big picture thinking, which I think is really missing in cannabis right now. I feel like people are very narrow-minded as far as what this looks like as an overall, wellness product, not necessarily just as weed. But like I said, now she's free from the big firms, and Shelia started her own thing. She actually owns a firm called Aura IP Law, which she started a couple years ago. I remember the day that she decided she was going to start her business officially was the first day that I got out of jail. And she called me, and she was my first real phone call. And I have to say, I am the happiest person in the world to know that I had something to do with probably one of the more important pieces, in my opinion, of the legal framework for the next steps in cannabis. For me, this kind of leads me into my first question for you, which is, what would you say is the current most vulnerable part of the cannabis business when it comes to, your expertise in the way of patents and trademarks? Where would you say that we're, lacking foresight?
Definitely. So I think, each of those has their definite weakness. For patents, I would say it is just not having any prior art. So the patent process involves an examination where you submit your application to the USPTO, the examiner then reviews it, looks and does a search and looks for prior art, then cites that prior art against you and says your invention is not new or it's obvious in view of what I found in my searching. The problem with cannabis is... It's
obvious? I don't understand. So if the invention was not an invention, they're like, oh, no, this was an obvious invention?
Right. So let's say the first hurdle is novelty. So as long as you're new, that's a really low threshold. Just needs to be different than what was done or what's known in the prior art.
Okay.
Once you pass that threshold, then you have obvious. Then the examiner will look at the closest prior art and examine whether...
When you say art, you just mean like a an image of what your invention is?
Could be anything, written article, an offer for sale, something they found on Google. It's often patent publications and non-patent literature references.
Okay.
So if you think about an examiner searching for patents, issued patents or publications and non-patent literature about cannabis, he or she's not going to find anything.
Nothing.
And so whatever I've then submitted as a patent applicant is going to get through.
Because it's unique.
Because according to the examiner and what the examiner can find searching, this examiner who may or may not have any, they're just on their computers. They have under 3 hours to examine the entire application. So you're talking about, they're not even reading your application. They're looking at your claims. They're doing a keyword search, pulling up what they can, seeing if it's identical. If it's close, they'll say it's obvious. And if they can't find anything close, then they say, yeah, this method looks great. This new compound looks new and non-obvious, and issues a patent.
So maybe it might be too easy for the patent to be approved because there's nothing.
Yes, I think that initially the biggest hurdle that the cannabis industry is going to face is that there are going to be some very broad patents that are issued, overly broad. And whether or not those patent owners become nuisances to the rest of the industry remains to be seen. Because if you get a broad patent issued, you don't have to enforce it, but you could choose to. And there is one already that a patent owner has a very broad patent to the purity level of the cannabis that they have then extracted, and they've already tried asserting it.
So somebody patented like a percentage rate of
Yes.
What was the percentage?
I think it might have been 95%.
So 95 exactly. So if it was more than that,
95 or greater. So, yeah.
So anything above 95, there is somebody in the world that
Thinks they own. Yeah.
thinks they own it.
Yes.
There is somebody in the world that thinks they own 96% THC.
Well, actually, that one was just, it might even be, and I apologize, I haven't reviewed it recently, but it might even be cannabinoids generally.
Oh,
It
overall.
yeah.
Uh-huh.
So, yeah. So you get a very broad patent, and then you become a nuisance, and you start suing people.
An industry nuisance. And so how would one even fight against does the industry have to bind together against the nuisance?
Absolutely. That's what's going to need to happen. So it's going to go defendant by defendant. Right now they're suing one defendant. And what I hope will happen is that the industry will come together, rally around this defendant, help this defendant invalidate this patent. Because once it's invalidated in court, even though the USPTO issued it and said it's a granted patent, once it's invalidated in court, it's invalidated as to everyone, not just that defendant.
So basically anybody who wants to produce more than 95% right now has to figure out what this is that we're talking about, go down the rabbit hole, do the research, figure out who thinks that they own it, and we have to rally around defending the person who they're litigating against?
Yes.
So they're currently trying to defend their patent against a business that is producing more the product that's 95% or greater, either, we're not sure, THC or combined, and they are suing said business so that they can make them stop producing that product.
Or pay
them money.
Yes.
Wow. Yeah, that is a nuisance, because to own a larger than a certain percentage of THC is just not, that doesn't even make any sense.
Right. And, if you think about it.
But the reviewer had no idea.
Exactly. So you have somebody who's very educated at the USPTO. Many of them have, advanced degrees. They're not all lawyers, but they're researching it, and who knows what their level of familiarity is with cannabis.
Right.
It might be none. And so if somebody has then, we're going to see the same thing, I think, with extraction methods. I'm sure a lot of people are using similar or close extraction methods.
Right.
Whoever was the first one to go and seek that patent will be the one who owns the patent, because unless the examiner found an extraction method that was similar already in the art, the examiner has no basis to reject it.
And they are approving things that say THC or CBD on them?
Yes.
They are approving them. That is really amazing. And these are process patents or product patents?
Products, processes, and plants. So we have already seen plants get through. I've seen processes, products. The U.S. government had a patent.
For CBD and THC at one point, right?
It was for, yes, it was pretty general, but it was for the use for medicinal purposes.
Of THC and of CBD, right?
Right. So, and I think that what's interesting in patent law doesn't require you to say that you've actually made the invention. You don't need a prototype. You don't need to have ever done it. You can conceive of it entirely in your head. As long as you can describe it in a way that someone else can make and use it, then that's enough to be eligible for patent protection. And so there isn't the same problem as we have with trademarks, where you don't need to you're not admitting to the government that you've done anything with cannabis.
Right.
When you're seeking a patent application. You're just describing an invention, something that you could do.
I was actually having a conversation the other day, and I was curious. If somebody built a patent based off of scientific research and later the research was proven invalid, does the patent become invalid or does it stay? Oh. So if you built something off of science that gets disproven, you can still fight your patent as like defendable?
Right. So the patent it's not a patent document. What defines the metes and bounds of the patent, the boundary of what it protects, is in the claims. And so oftentimes there's a lot of stuff in a patent application that is just support. Some of it's nonsense.
Right.
Because the only thing that matters are the claims. And so if it was later found that it was inoperable, then you probably just wouldn't assert those claims. You wouldn't have a reason, but they're not, the USPTO isn't going to go back and go through and
find them.
Right.
Wow.
So unless you're asserting that somebody's infringing your patent and somebody wants to invalidate it, then it's just going to exist and be there.
Huh. Well, I am very glad that I have friends like you, and that there are people that are stepping in right now for cannabis and IP protection, because this is obviously a very confusing piece, and we're, as an industry, already pretty confused as it is. So I'm very thankful for you, Shelia, and helping us kind of get through all of this. I really recommend, if you own a company, to at the very least spend some time figuring out what the next steps are to protect yourself, and getting those things ready, because everyone keeps complaining about how big business is going to show up and take everything, and this is one of the few things that we can really kind of cover our asses on and get done now, as we're readying for the next step. So thank you for all that insight on that, and we're going to go ahead and turn over to Sada, and we're going to hear a little bit about the moon and the stars and why everything's a little crazy these days.
So yesterday, Mercury entered Leo. Shout out to all my crazy-ass Leos. And Mercury is the planet of communication, learning, expression. So it's really a good time to get in touch with your inner confident, Leo lion, as they say, and let your ideas flow. And if you still haven't figured out your quarantine side hustle, now might be the time, because I heard that extra unemployment money is gone. So follow your instincts, be firm, and direct when you express yourself. And in the words of Young Ma, be an unapologetic, I said what I said, bitch. I said what I said, bitch. That is so true. I have been channeling my inner Young Ma lately, so I really appreciate that. What is that? That's from the Bad Bitch anthem, actually, which I think I listen to every morning as I get ready. But yeah, thank you, Sarah. It's been an I said what I said kind of year, I feel like, which brings me to the BCC released fact sheet that just came out regarding branded merchandise. That is my dumb law for today. And again, this is not necessarily a dumb law. It's a lack of fully understanding what's happening to the overall industry when we write these laws, and this is a continued issue that we have in cannabis, where the policymakers don't fully understand what's actually happening in the industry. And so we recently received a memo, a clarity memo from the BCC regarding branded merchandise, because from what I understand, there was a lot of confusion, and from what I've heard, this was given to help people understand that no, in fact, we can't sell CBD products with our cannabis branded merchandise or cannabis brand on it. And I think that's kind of what brought this to full fruition. And in that process, I think we're realizing that, in fact, that was not
done in a way that's going to make sense for all of the branded merchandise. So the new regulation came out, or not new regulation, the regulation was changed at the beginning of this year, but the clarity memo came out explaining branded merchandise, which includes clothing, hats, pencils, pens, keychains, water bottles, beverage glasses, notepads, lanyards, or cannabis accessories with the name or logo of a state licensed commercial cannabis business. So that is what they consider branded merchandise. Now, branded merchandise does not include items containing cannabis or cannabis products or anything that is considered food. I don't fully understand the end part of considered food because I don't think it's legal for us to manufacture food as a cannabis brand that's not cannabis product. And if it was cannabis food that was an edible, it would have to have the license on it because it was manufactured in the cannabis facility. So that just seems like a really roundabout way of saying everything but weed. And a licensed retailer may sell their own branded merchandise to the retail customers, which is awesome. But retailers are not authorized to sell branded merchandise to other licensees. Of other licensees, not to them, sorry, of them. So a licensed distributor may distribute their own items or another licensee's branded merchandise. But to who? Because the line before that says retailers are not authorized to sell branded merchandise of other licensees. But the distributors may distribute other licensees to who? And is it saying that if you have a product that has your brand on it and you're not a retailer, that you have to give it away? And then the memo goes so far as to explain branded merchandise is considered advertising and marketing and is subject to the advertising and marketing requirements of MRCURSA, which states that all branded merchandise must identify the license responsible for the advertising content by adding the responsible licensee state license number on the branded merchandise. It cannot be sold while a licensee's license is suspended, and it cannot be designated in any manner likely to appeal to children. So what this is telling me is every item that is produced with a brand that has a license must have a license number on it. Is that how you read it?
Yes.
Okay. So everything has a license number. If it's not weed, well, and the part that was even more annoying is it says not cannabis. Well, if it is cannabis, it still has to have a license number because it should have had all of its packaging information, besides the point. But the non-cannabis items, branded merchandise, put a license number on it. Okay. Would you consider a vape pen battery, not the pen, not the cannabis, would you consider a battery to be considered merchandise under this clarity regulation?
Under the regulation, the way it's currently written, yes.
Yes.
To me, anything that's not cannabis, so if we're talking about just a battery, and it's a distinction I make every day in my trademark practice, is I can get a trademark for a battery because it's not cannabis. It's not plant touching. And I tell clients all day long to brand some batteries, and we can get them in smoking articles, class 34, for their trademarks.
Right.
But to me, yes, the way that it's currently written without further clarification, that would fall under branded
merchandise. So unless your battery is being sold with a cart, that is gray, if not completely illegal based on this regulation, that even if it had the number on it, from the way I'm reading this, there's nowhere for you to sell it in a licensed business. You'd have to find a new method of sale.
Unless you have your retail license and you can sell it yourself.
Right. Like some of the brands, Sherbinski and Cookies, they have clothing stores and that sort of thing. And then that goes even further. Does that mean that if I have an apparel line that's the same brand as my cannabis line, does that mean all of my apparel needs to have the license number on it?
The way I read that, yes. And what's not clear to me is where it needs to be. Does it need to be prominent? Do I need to be able to see that on the shirt that you're wearing, or can it be on the neck tag? Can it be on the inside?
This regulation got clarified in regards to billboards a few months back, and it did clarify. And so for all of you out there with billboards that don't have your license number on it, rethink that, go get your license number put on that billboard, where they said, that the license number had to be on the billboard, but there was zero clarity on like size or visibility or anything like that. So when you go to these billboards, you see some of them, I mean, there are some of them that it's this big, physically this like 6 inches, and it's a 30-foot billboard, and the license number is tiny in the bottom. And I'm not saying like, don't do that if you don't need to make it super prominent, but like there's no baseline. We have no understanding of like where does the license number go? How big does it have to be? Do people have to see it? Like that clarity is not there. It's not in the MRCURSA regulations. It's not in any of the memos. There's nobody giving us clarity. And then it states that every single item out there would be considered a marketing violation and is subject to fines. So does that mean like every shirt? Like if I rolled out on the street and I found a bunch of people in your t-shirts, could I fine you for that? Like that's insane. And then who's to say this was a new shirt or an old shirt, right? Like at what point was this shirt produced? Because there was a time when that wasn't the case.
Right.
There was a time when that wasn't, the requirement. Do we have a window to get all that shit out of here? Do we have a grandfathered in? Can these shirts still be on the market? Do I have to have a recall for my shirts without the logos? Like, do we have to are you going to call the cops on me if I don't have a number on it? Like, where is this? Where is this going to be enforced, and how is it going to be enforced, and how can we make that transition without wasting, unfortunately feels like millions of dollars, going through? And do we have to throw away all of our old stuff? Is this like with cannabis, we at least had an understanding, like with the packaging laws, we have until this day to get it sold. Like, can they give us that? Like,
and that's what I think we all need more clarification on, because the other thing is, what about giving it away versus selling it? So
are we allowed to give it away? It says about selling it. Can a retailer give away a non-retailer's licensed product? Can we give away shirts and hats and keychains? Because that's been the only cool thing that they can let us give away.
Right.
Is stuff, right? And so now you're taking away our ability to give away stuff. If we can't even have it has to be only our stuff. We can't give away the other brands, which is absolutely insane. But it kind of leads me to my main question for this. Like, what do you feel like is the purpose of creating such a restrictive rule? And, do you think that there's going to be reform in this? And if it's not already on the way, like, do you think we need to request/demand it?
Yeah, I mean, I think the purpose is good. I think the intent is probably, their main intent would be to keep this out of the hands of children. You see that in the under 21 portion. So I think the main purpose is we don't want cannabis brands to be advertising to children. And maybe that's because of the, you see the big backlash of the tobacco industry. And so, but the thing is, have they gone too far? Have they been too restrictive? And so I do expect some pushback. If we're interpreting it the way that we're reading it right now, I do expect there'd be some pushback, because it does seem undue. It does seem too restrictive.
Yeah, I feel like the cultivators and manufacturers really need to stand up here, because the only location for sale is the retailer, unless now you're expecting these people to also create a sales channel for stuff. And it's like, that's ridiculous. The stuff is supposed to go with my weed so that I can sell the shirts and or give them away. And why wouldn't we create that clear chain of, I understand, okay, fine, the license number needs to be on it. I'm not going to fight that argument. But like, why can't I sell the shirt with the license number of the grower of the farm that we sell all of their weed? Like, why can't that shirt be for sale at my store?
Right.
I don't understand, like, what would the logic be behind that? Like, why would you stop me from selling and helping these farmers make a little bit more money? Because it's...
Well, I think it shows a lack of understanding of how it's divided up by the licenses and how things are really operating. And so I right now, I don't think we have those answers to those questions.
And it creates a really interesting place for micro businesses as well, because the micro business is really the only one that's not drastically affected by this if they have their brand licensed correctly with the retailer. Because at that point, that is the most interesting piece of all of it, because if that brand is licensed across the board of your micro business, that could be a cultivation, it could be a manufacturing, and a distribution with your retail. So you could, in theory, as a micro business, be okay to be able to sell your brand throughout the store. But at that
In your own store, right?
in your own store.
Right.
But you would at least be able to sell for the
Right.
farm and for the distribution at your store. But now you couldn't get that out of your store.
Right.
Which, the only people who have any ability, as I see right now, as a farmer or an extraction company to sell their product is a micro business. And most of those businesses are, struggling to get 4 businesses or 3 businesses going at once. Like the financial expenses of getting 3 businesses up and running at one time is insane. So like they probably don't even care about the t-shirts or the cups, or whatever. But, some of these farms that are trying to get apparel and get their brand recognized, that's really the only way to do that is stuff.
Well, I think maybe we'll be getting a lot more of those mints.
Right.
The branded mints. Seems like maybe that would be
Oh, is that the food thing?
I don't know.
Oh, except for food. Are we allowed to do that? Are we allowed to, I don't even know the answer to that. If you're allowed to
Non-infused?
Non-infused.
The way that I read that, because if you look at it, it said cannabis containing goods or food.
Right.
So the food seems like it doesn't have cannabis in it.
I'm going to start.
Mints in water bottles with labels on them.
Okay. You don't need your license number on your water bottle? Was food?
Water bottles was on there, wasn't
Bottles were, but like, oh yes, it's
Is water.
food.
Now
Is
you're-
water. Now we're going down the semantics
now
road.
we're way down the road.
Oh man. Okay. Well, thank you, Sheila, for all of that insight. Honestly, I am so glad that you're able to come and kind of help us get through this. But you know what? Honestly, I feel like I end up with more questions than I end up with answers when I talk to people that understand what's actually happening. I walk away now. I've got a whole list of new questions, and for that reason, I hope that we can, circle back to this. And I know that you've been working on getting things going for your own kind of podcast, so I would love to be able to direct people to hear from you. Also, definitely check Sheila out, araiplaw.com. And, I just want to say thank you so much again for coming out, being my friend, and being, a fighter for what's right in this space. It's been quite a battle, but knowing that there's people like you definitely helped me rest easy at night.
You're welcome. Thank you for always supporting. And, one of the things that I learned that really helped getting into this space is, if you're going to be a lawyer in this space, you have to get comfortable not knowing and telling clients, I don't know the answer to that.
Yeah.
And it really is. There's just so many, like you said, you try to answer one question, you come up with, 10 additional questions.
Absolutely. I mean, and that's the truth with cannabis in general. Right now, as it stands, we're continuously getting one little bit of information. I'll read some research about that Meshulam dropped, and I'm just like, wow, this is so interesting. But now I feel like I know even less than I did yesterday. I know less, which I think it's a positive piece of growing, and I think that we're all in this together. So again, thank you so much. And with that, we will get a little message from our sponsors so that we can make sure to pay all these bills.
Since 2008, California Lightworks has been guided by a vision focused on the research, design, development, and manufacturing of state-of-the-art commercial LED grow lights and automation equipment for greenhouse and indoor horticulture. By applying the latest advances in high-efficiency, solid-state lighting and controls technology, their team provides worldwide growers new grow lights that deliver clear benefits at a competitive price. Backed by their solid reputation for standing behind their products, California Lightworks also offers industry-leading warranties on all their commercial grow lights. To learn more about California Lightworks, go to californialightworks.com, and to view their current investment opportunity, please go to the investment marketplace at razzle.com.
Welcome back, and thanks again for tuning in to our second episode of Sensible Dissent, where a couple of misbehaved women make a little history. And now for our best part of every episode, where we award today's Golden Cock Trophy. Today's Golden Cock Trophy goes out to Jenny Rose LLC for obtaining their patent for their hydrocarbon extraction method. This was actually brought into fruition because in 2008, Jenny Rose Castillo, Jimmy Castillo's younger sister, was diagnosed with ovarian cancer. This prompted Jimmy to start all kinds of research and develop education so that he could figure out various cannabinoid treatments for cannabis. Over the course of 3 years, Jenny unfortunately battled cancer and she lost. We unfortunately lost Jenny, but in this process, Jimmy was inspired to open up his own dispensary, grow and extraction facilities, to start formulating specific cannabinoid profiles to treat various conditions. And his patents were presenting this process. So he has actually been able to patent a cannabis extraction method using hydrocarbons, which is very exciting. So thank you so much, Jimmy. You get today's Golden Cock Trophy on behalf of Jenny Rose Castillo. So now on to probably the saddest part, but the most important portion of every episode, where we bring light to somebody who is currently incarcerated for cannabis in the United States. And today's prisoner is Lance Glore. Lance Glore was sentenced on June 3rd, 2016 to 10 years in federal prison, plus 5 years probation, for running a Washington state medical marijuana dispensary. His charges are conspiracy to distribute and also manufacture cannabis. Conspiracy carries 5 years mandatory minimum sentence, which is insane because conspiracy basically just means that you talk to somebody to commit the crime. Lance chose to go to trial and stand up for the MMJ industry rather than cooperate with the investigation. Unfortunately, because Lance chose not to accept numerous deals that he was offered, he ended up having to go to jail for 10 years over cannabis. For a fucking plant. So you can click the link in the description and sign the petition that Lance's father developed for him on change.org. And also please send him a letter of hope. We'll put the address at the end of the show. And Lance, thanks for fighting for the industry, and we are so sorry that that had to happen to you.
And now we're going to pull some cards from the Queen of Stones Power and Magic Goddess deck and see what messages our guides and ancestors have for us today. Thou shalt not let weird-ass energy penetrate the aura.
Ooh, love that one.
I read that in Peachy's voice. Be a giver and a taker. Give no fucks, take no shits.
Ooh.
Sometimes the hug you need is the one you need to give yourself. Which I think is very accurate with all the stuff going on right now in the world. Be humble, but don't be a doormat.
Ooh. That's a good one. I really
That's very important.
Yeah, that's a really great read. So also, if you want to get a hold of a deck of these cards, you can go ahead and find them at thequeenofstones.com. Thank you again, Sarah and Sheila, for imparting all of your insight in today's episode. And thank you all for tuning in to episode 2 of Sensible Dissent, powered by Razzle Cannabis Broadcasting Network, WCBN. And remember, well-behaved women rarely make history.
And don't forget, Brett Hankinson, Miles Cosgrove, and Jonathan Mattingly are still walking free after murdering Breonna Taylor in March of this year.
Sad news, but you know what? We can make a difference. So figure out how to bring justice to Breonna Taylor. And thanks again, Sheila, for coming out and giving us all of your amazing knowledge.
Thank you for having me.